All right, perfect. Good morning, everybody. Thank you all so much for joining us this morning for our training for our legal advocacy series. Our session today is going to be about domestic violence, orders of protections. What is domestic abuse under the law? And what is the process for seeking an order of protection? We are streaming live on Facebook. So those of you joining us on Facebook, please go ahead and put your questions in the chat. I will keep an eye on that. And for those of you joining us on the Zoom meeting this morning, thank you for joining us as well. You can place your questions in the chat. The session is recorded and is being streamed on Facebook as mentioned. So we are gonna have a session at the end of this training for about 10 minutes where you all can ask your questions. We will not be recording during that time. So just if there's anything that may pop up for you, you all have your privacy for that time and will not be shared. There's also some resources and this PowerPoint that I will be sharing with you that Sarah Coffey has created. So you will get that in your email after this training. And there will also be a survey for you all to also get a certificate by attending this training today. So with that being said, we are joined by your amazing facilitator, Sarah Coffey. Sarah Coffey is the Victim Services Manager at New Mexico Legal Aid. Thank you so much, Sarah, for being here with us today and doing this series for our legal advocates and also educating our community.
Absolutely. Thank you so much for having me. I'm really excited to be here today. So as Terry said, my name is Sarah Coffey. I am the Victim Services Managing Attorney at New Mexico Legal Aid. I have been an attorney since 2013 and have been working in the areas of domestic violence since I started law school in 2010. So I've been doing a whole lot in this area for a long time. Today we're going to talk about orders of protection. I am a very informal human being. So if you have questions that you're comfortable talking about in the group or you want to shout out, please don't hesitate. Unmute yourself, talk to me about things. If things don't make sense, like I want you guys to actually understand what I'm talking about. So just don't hesitate to interrupt me at any point and let's talk about things more. Just like she said, though, if there are things that you want to kind of wait and you don't want to be a part of the recording, we are going to have a little bit of time just for a discussion at about 10:50 to make sure that everyone has a comfortable space to be able to talk about things in. So I am going to share my screen with everyone because, you know, we live by a world of PowerPoints now. So that's just what we do. All right. Is everyone seeing the PowerPoint up right now? Okay, perfect. If anything happens, I've had some weird technical things because, you know, it's the world of Zoom now. So please just pipe up and tell me I can't see something or whatever's going on. So I want to just start out by giving you guys a little bit of information. New Mexico Legal Aid does represent domestic violence survivors for orders of protection hearing and sometimes for divorce and custody cases. It does depend on capacity, and if your organization doesn't have a referral process with New Mexico Legal Aid and you want a referral process with New Mexico Legal Aid, reach out to me and let's get that set up. And we can also talk to your organization specifically about like how we assess cases and what kind of cases we take. For now, I do want to point out we do have a domestic violence helpline, and that phone number is at the bottom of the screen here. You're going to get a flyer with that to give out to survivors as well. This is a Monday through Friday, 9 to 5 helpline for legal advice, which is really important to people. All right, I just want to jump right into talking about what domestic abuse is. So we all know what domestic violence is. We work in this area. We know the types of things that people experience. But one of the things that I think is really important to understand is the world of domestic violence, which you work in, which social workers work in, which therapists work in, which advocates work in, is different than the world of domestic violence that I work in. So the legal definition and the cultural definition of domestic violence are very, very different things. And your definition is large and it involves a lot of things that people experience. The legal definition is much, much smaller. It does not have near the same amount of things that people experience. And I want to start by saying that because not everyone who is a survivor of domestic violence that we in more of the social work circles know of can qualify for an order of protection. So what I'm talking about is the legal definition of domestic abuse, and that is for how you get an order of protection. So I want to just start by saying that, and we'll get into that a little bit more as we go along. But I do want to just recognize that this definition that I'm talking about leaves out a lot of things. And we know that, but I think it's important that you guys know the holes that exist as well. So the first type of thing is people who can get orders of protection regardless of whether or not they know the perpetrator, have a relationship with the perpetrator, doesn't matter. If you are the victim of sexual assault or stalking, it does not matter who the person who sexually assaulted or stalked you is, you could qualify for an order of protection. So once again, legal definitions. So for stalking, there is a very, very specific legal definition under the criminal code. And it's knowingly pursuing a pattern of conduct without lawful authority directed at a specific individual when the person intends the pattern of conduct would place the individual in reasonable apprehension of death, bodily harm, sexual assault, confinement. This is a really high standard. Like, this is not easy to meet. It sounds easy to meet. Like, you think, okay, I have 400 calls on my phone. That's stalking. That's just kind of a no-brainer, right? Well, the problem is this idea of would place an individual in reasonable apprehension of death, bodily harm, sexual assault, confinement, or restraint. That's a high standard. You have to actually explain why someone feels that way and why it's reasonable that they feel that way. So a lot of times when there's stalking activity going on, they may or may not be able to get an order of protection. The court's a little bit more inclined to provide it to people who are being stalked in more of a relationship or a former relationship situation. I would say the thing that I see that they're very, very hesitant to grant is a case between neighbors. And we see this a lot where the neighbor is recording them and yelling at them and stuff like that, because this definition is really hard to meet that category of violence and that category of fear that you have with neighbors. We see a lot of neighbor cases, and I would say that they're one of the most challenging stalking cases that exist. Sexual assault, there is no criminal definition of sexual assault. There is a definition in case law that says offensive touching. So touching is one of those things that requires actual touching. So obvious forms of sexual assault are going to be rape, groping, molestation of children. All of these things qualify for orders of protection. Some of the things that we try and sometimes are successful, sometimes are less successful. And, that's the annoying thing about the law is there's no bright lines for the most part. Indecent exposure. There's no touching there, but I consider that to be a sexual assault. If that happened to me, I would have that same feeling. So I think it's worth trying to get orders of protection if something like that is happening. Sexual harassment. One of the big things that I've been seeing a lot lately is the revenge porn. I think that's a sexual assault to put out those kind of videos or pictures without consent onto social media. But it doesn't necessarily fit that touching definition, but it's always something that has a huge impact. And I think that it fits the definition of sexual assault. I think it fits the definition of other things if you are a household member as well. But sometimes, I think the most wow one I saw was someone was using revenge porn against her daughter-in-law. Don't quite understand that situation, but it was happening. And so It was something that was just a little bit outside of the norm that I still think it was worth going on. Okay, so then there are other things that happen if you have this household member status. Now, let's just take a moment and appreciate how dumb this legalese is here. I'm sure you guys have all heard the term legalese. This is the definition of legalese. You do not have to live in a house with someone to be a household member. And just because they live in your house does not make them a household member. So, yay. So a household member is specifically one of these people. So a spouse, a former spouse, parent, present parent, step parent, present or former, I can talk. Present or former parent-in-law, grandparent, stepchild, grandchild, co-parent of a child. Another bit of legalese in here. A person whom you have a continuing personal relationship. Before I was in law, I thought I had a continuing personal relationship with my aunt. I talk to her a lot. We spend time together. She knows things about my life. I know things about her life. No, that's not what that means. A continuing personal relationship has a very specific meaning of a dating relationship. So this is boyfriend, girlfriend, ex-boyfriend, girlfriend, that kind of thing. Once again, cohabitation, not necessary for a household member. So just because they live in your house doesn't make them a household member. You don't actually have to live in the same house to be a household member. So if someone meets one of these definitions of relationships, domestic violence is bigger. Any of these acts on the screen now equal an act of domestic abuse if you have that relation. So I'm going to go through all of these and kind of give a little bit of an idea of what all of this means, but I'm going to skip the second one and talk about it at the end. So physical harm, that's pretty obvious. If you have bruising, that's physical harm. Bodily injury or assault. It's kind of similar to physical harm. All of these things kind of intersect, kind of don't. There's some repetitiveness going on. A threat causing imminent fear of bodily injury. So if I get in your face and say, I'm gonna punch you, that would be a threat causing imminent fear. If I am in New York City and I call you on the phone, I have no plans to travel to New York City or to New Mexico from New York City. I have no means to do that. And I get on the phone and say, I'm gonna punch you. I mean, that's not really an imminent fear because I would have to fly from New York to New Mexico to be able to do that. So that imminent fear is actually important. But some people will do that. Let's be realistic. Like some people will fly from New York to New Mexico to do that. You just have to explain why that fear is imminent. And that's an important thing to be able to explain. Criminal trespass, so people can't go onto your property in a criminal way. Once again, this is something that has a criminal definition you'd have to meet. Criminal damage to property, also criminal definition. But one of the things that I think is important to point out is criminal damage to property. People are always like, oh, yes, but I own this house, so I punched walls in my own house. Yeah, there's actually a way around that because there's something called criminal damage to property of a household member. And pretty much the goal is even if it's like joint owned, if it's done to intimidate and create fear, it can still be a crime. I would say the criminal damage to property is one of the more common ways to get an order of protection if you're a victim of emotional abuse. When someone's getting in your face yelling, sometimes they punch holes in walls. Sometimes they break cabinets. Sometimes they break doorknobs. And most commonly, they break cell phones. Like the amount of cell phones that are broken. Breaking your cell phone is in and of itself an act of domestic abuse. And that's an important one to remember because The cell phone is how you are connected to resources, to 911, to family, to get yourself out of that situation. And when someone breaks the cell phone, it kind of cuts you off and it isolates you. So remember that when you're talking to people, if they come out and they're like, well, this and this and this happened, and you broke the phone, there's a, or even if it doesn't fit any other parts of this definition. Repeatedly driving by a residence or a workplace. This is one that I think it's really good that it's included, but it's really hard to prove. It's getting a little easier to prove with all like the Ring cameras and stuff that exist, but ultimately it's hard to prove that someone's driving by your house because you can't even say, yes, I saw his truck. You have to say, I saw him driving his truck. And that's the other thing, unless they have a car that is like the only one because they've done a bunch of weird things or they have a bunch of very specific bumper stickers in a specific way. Saying I saw the car is not going to be enough. So what if it's a different white truck that's driving past your house? What if you're being stalked by a different person than the person who everyone knows is stalking you? And taking a moment to appreciate how high of a bar that is for a survivor and how stupid it is for a survivor to have to prove, I think is important. Because it's the same thing of, oh, well, my ex slashed my tires. Okay, well, how do we know it was them? Because duh is ultimately the answer. But unless you have someone saw them, you have one of those Ring cameras that saw them, something like that, we can't prove that it's not just like the neighborhood kids screwing around. And that's one of the really frustrating things that survivors go through. And so not only do you have to have one of these things happen, to be able to prove that it's that person who did it to you. And that's an important thing to remember, especially with this driving by workplace. Like I said, with the damage to the property, tires, things like that. Telephone harassment, once again, telephone harassment is a type of harassment. I don't know why we had to say it twice, but we did. So those are also defined by criminal law, saying that they have to do it with a purpose of annoying, harassing, terrifying, all of that kind of stuff. Strangulation and suffocation. I'm sure you guys have all heard about the dangers of strangulation and suffocation. I'm not going to go too much into that today, but just know that that's a really high lethality indicator. That is something that we take very seriously. That is something the courts take very seriously. And I have to say, in my experience, the order of protection courts take it more seriously than like the criminal courts do. So if that's going on, make sure and put that in the order of protection paperwork if they're applying for one. Okay, I'm going to go back to severe emotional distress now. So severe emotional distress is not emotional abuse. Yelling, name calling, those kind of things usually are not going to be enough to get someone in order of protection. This is a very high bar, and depending on which judge you're in front of, it's an even higher bar. Some are a little bit lower. Some examples of times that I saw courts give orders of protection where severe emotional distress was specifically stated. I had a situation where the abuser was a male, my client was a female, and she locked herself in the bathroom because he was being so awful. Just the emotional abuse was so incredibly extreme. And he sat outside the bathroom telling her how worthless she was and how she should kill herself. And she tried. And it was awful. And that the court gave the order of protection for severe emotional distress. Like that is never the degree that we want someone to be in to be able to get help. Like, let's just acknowledge that. It can be lower sometimes. It just very much depends on the situation, and it very much depends on the person. Severe emotional distress for survivor A may not cause severe emotional distress for survivor B. the exact same actions, they're going to be able to handle differently. They're going to deal with differently. They're going to have a different situation. So I want to point this out because severe emotional distress is not emotional abuse. When people say verbal abuse and emotional abuse, you have to get a lot deeper if you're going to get to this severe emotional distress place. And I just want to make sure that everyone understands that, because emotional and verbal abuse can be absolutely life altering. And like going back to what we were saying before, the social work, the counseling, the work that we're putting in to help survivors of abuse, that is different than the legal definition of domestic abuse. This is much more narrow, and this is a way that it's much more narrow. So 2 more things on this slide. I want to point out that the use of force in this way is not in self-defense. So you'll see people have like orders of protection against each other. One person saying, oh, my partner strangled me, and the other person saying, oh, my partner scratched me. Guess what you do when someone's strangling you? You scratch them. You do anything you can. So that just because you use force to protect yourself does not mean that you are acting abusively. That's not to say that 2 people can't be acting abusively at the same time. There's usually one person who's a little worse, but 2 people absolutely can be acting abusively to each other at the same time. But it doesn't mean self-defense. If one person is fighting for their life, they're not abusing the other person by fighting back. They also note that it's a defense of another. So if you're defending a child, if you're defending your child, like, I don't know if there are any parents here, but people will defend their children, and that is not abuse. And that's really important to remember. Even if they're defending like their mom, their friend, whatever, their boyfriend, if their ex comes out and they're trying to defend their boyfriend, that's not going to be abuse. Okay. Like we talked about, there are some things that have criminal definitions. There are some things that don't. I'll be honest with you, some things I really like that have criminal definitions. For instance, like criminal damage to property. It's really nice that I can say, well, under criminal law, X, Y, and Z are the elements, we've met them, the end. Being able to have a little more wiggle room is kind of nice. For instance, the physical harm. I had a case where the offender ran over her foot with a car, and they were like, well, he didn't mean to do it. It's like, well, there was an argument. I disagree that he didn't mean to do it, but I don't have to prove that he meant to do it. He caused harm. The end. So sometimes it's helpful for people. Sometimes it's a little bit more challenging because there's not really anything spelled out. Okay, so once again, going back to this broad definition versus the statutory definition, there was one portion of, I'll just go back, domestic abuse that I didn't talk about, and that's harm or threatened harm to children as set forth in this paragraph. So that means for you to get an order of protection on behalf of your child. So let's talk a little bit about what that means, because I think it's really important to understand, because parents are put in really challenging positions when abuse is happening that is not one of those specific definitions. Because it does not say child abuse. There are acts of child abuse that are not domestic abuse under our Family Violence Protection Act. So some examples, the clearest example I can give you, let's say mom is driving drunk with child in the car. Mom gets pulled over, gets arrested. Police are going to charge her with child abuse and DWI, and they're going to call the child's other parent to pick them up. That other parent then says, oh, child's mother was driving drunk with them in the car. If I give the children back to them, I am afraid she's going to drive drunk with them in the car again. I want to protect them. I want to file for an order of protection. It does not meet the statutory definition. It isn't a threat. It doesn't fit one of those aspects. I'll go back. Doesn't fit any of these. Having your parent drive drunk and putting the child in a situation where they could be seriously injured, it doesn't actually fit any of this definition. So let's change the scenario a little bit. Let's say that mom's driving drunk, but let's say she gets in an accident where the child has some injuries, even if they're very, hopefully, minor injuries. Now that child has an injury. Now that child has physical harm done. Now the other parent might qualify for an order of protection on behalf of the child. It's not the best, because that's not the circumstance. You don't want to have to hope that the child gets injured. That's terrible. But that's the reality of our current law with domestic abuse. Just a few other situations. Let's say that you have a custody order and child has to go to dad's house every other weekend, Friday through Monday, they're at dad's house. And Monday nights they come home and they tell you that dad doesn't feed them when they're at the house. That's very clearly child neglect, like very clearly. And obviously the first thing to always do when there's some kind of child abuse or neglect is to call CYFD. But it doesn't qualify for an order of protection. So until you get a change in your custody order, which can take a lot of time, file emergency motion and ask for a hearing as soon as possible, but they don't qualify for an order of protection. So there's no way to immediately stop that utilizing orders of protection. We're going to talk on our next series a little bit more about the domestic matters court, custody, and divorce and stuff, and we'll talk a little bit more about that then. But I just want to make sure everyone knows the limitations that orders of protection have in regards to children and their safety, because it is challenging. Like I said, emotional abuse, rarely considered domestic violence or domestic abuse under the Family Violence Protection Act. Specific examples of things that I have talked with hearing officers about that are not considered domestic abuse are name calling, yelling. The one that really is hard for people is these vague threats. Just you wait, you know what'll happen, all of those things. Those usually don't meet the burden unless, okay, well, last time this happened, the person did X, Y, and Z, so they're alluding to that. So, you can try, but the just general vague threats when there hasn't been a physical history of physical abuse, those usually are not considered domestic abuse under the statute. Threatening to take the children. This is a big one. Because that scares the crap out of people, saying, oh, well, if you don't, whatever, I'm just going to take the kids and I'm going to go back to my parents' house in Iowa or whatever, and you're never going to see the kids again. That's actually not domestic abuse under the law. Judges are going to say that that's a custody matter. Threatening to make false reports to police or CYFD. I see this in orders of protection a lot. I'll be honest, I see it more from the abusers trying to get orders of protection against survivors. But it is a tactic that abusers can take where they use the system against people. And sometimes it's a fairly successful thing to do. But just threatening to make a false report is not an act of domestic abuse. Drinking and using drugs around children, also not domestic abuse. Something's got to actually happen that meets those definitions. Other thing I just want to flag is this is mostly emotional abuse we're talking about. Financial abuse isn't talked about at all in the Family Violence Protection Act. So that situation of complete financial control that keeps survivors there, that is not contemplated in the Family Violence Protection Act. And it's just something for you guys to know about. Before we go on, does anyone have any questions about these kind of types of abuse and the difference between what we think of as abuse and what the law thinks of as abuse? Nothing? Okay. All right. So let's talk a little bit about what the types of orders of protection are and what these processes look like. So there are a bunch of different types of orders of protection. And then at the end, I added civil restraining orders because those are different things. And sometimes they're important, sometimes they're not important. So real quick, let's go over a couple of different things. So emergency orders of protection are something that's filled out by law enforcement. So this has two requirements. It has to have an act of domestic abuse happened, and the individual is in immediate danger of more domestic abuse. So if we don't keep these people apart, the survivor might be injured further. I don't think that the police issue these as much as I would like. I think there are a lot of situations that these should be issued where they're not issued. The judge has to sign off on them. So the cop calls the judge in the middle of the night and says, hey, sign off on this. And they look at it and they decide whether or not to sign off on it. And they're in effect for either 72 hours or the end of the next judicial day, whichever comes first. So this is if an act of domestic abuse happens at 5:15 on Friday, well, they can't file for an order of protection until Monday at 8 o'clock. So an emergency order of protection can keep them safe through that weekend. Or, in all honesty, Tuesday at 5:30, if something happens, well, we don't know what's going to happen at 6, at 7, at 8, at 1 o'clock in the morning. So an emergency order of protection can keep things, it can be in effect until they can get to the court the next day. So that's the purpose of that. The survivor does need to go to the court the next day and file a petition for an order of protection because that emergency order will expire that next court day, the next day that the court's open. They're enforceable the same way temporary orders of protection and extended orders of protection. So if you get an emergency order of protection and the perpetrator comes 2 hours later, police can arrest on a violation of the order of protection, just like they can anything else. So this is something I included just because I think it's really important that we talk about it, because not a lot of people talk about it because it doesn't happen a whole lot. So when the survivor goes to the court and writes out their petition for order cause, so they're supposed to look to see, did they make statements saying that the other person abused them? Does it meet this definition under the law? And if it does, they're supposed to issue a temporary order of protection. And we'll talk a little bit more about the temporary orders of protection here in a little bit. If this person writes stuff out, but the judge just doesn't see the abuse or doesn't understand what's going on, they can issue a 72-hour order to appear. This is a one or the other. So they either dismiss it saying, no, there is no domestic abuse listed, there are no household members, whatever they say for the dismissal, or they issue the temporary order of protection. The only other option you have is this order to appear, which requires that a hearing be held within 72 hours. I've seen some courts issue orders to appear 10 days or more, like almost like they would a normal temporary order of protection time period. That's not what's supposed to be happening under this law. They're supposed to be getting people in as soon as possible and giving the survivor an opportunity to say what's going on. So, and then once they get the opportunity to the survivor, they decide either like, no, that actually isn't domestic abuse, or, oh, okay, I missed X, Y, or Z in the petition, or you didn't write X, Y, and Z in the petition, but you alluded to it, whatever, and then issue the temporary order of protection and have that temporary order of protection hearing. The survivor can talk to the judge usually, even if the other party isn't served for these 72-hour hearings. You don't have to have the service. They are supposed to make an effort to serve the other party, but you hold them either way. So some examples I've had is I had a client who had one of those brain fart moments, and on date of abuse, she wrote 2012 instead of 2021. And so the judge looked at him and was just like, why are we here now if this happened in 2012? And she went in and said, oh no, I meant 2021. Oh, okay. And just issued the temporary order of protection. It happens a lot of times where it's more of the emotional abuse going on, where they're like, I don't know, I need more information. So these things might happen, and it freaks people out when they do. And that's why I wanted to kind of flag them. They're pretty quick hearings. They're usually pretty low stress hearings in once you know what they're going to look like. It's usually just the survivor in front of the court saying why they need the order of protection. And then the judge or hearing officer listening to that and deciding from there what they should do. Terry, do we have a question?
Yes, we have a couple.
Okay.
There's a participant that asked, does the emergency order of protection also grant temporary custody of any kids for that time period?
I'm trying to look at it in my head right now. If you're wondering what the facial expression is, I'm trying to actually see the piece of paper. I don't think it does. I think that that is just a pretty much a baseline stay away order, but I'm not 1,000% sure of that. But I believe usually it's just a stay away order, and the temporary order of protection will decide the where the child should go.
Perfect. Thank you. And then there's another question from another participant. Clarifying question. If a client gets an emergency order of protection at 1 p.m. on a Monday, when would the order expire? 72 hours from 1 p.m. on Monday, correct?
No, if they get an order of protection on Monday, 1 o'clock on Monday, it will. So if they get it at, time is breaking my brain, so I'm going to change that just to make sure I answer it correctly, and then I'll try to make sure that we're on the same page. So let's say they get it at 11 p.m. on Monday. It'll expire at 5 o'clock on Tuesday, at 5 p.m. on Tuesday. So it's the next judicial day or 72 hours. So the 72 hours is usually only going to be used over weekends, holidays, that sort of thing. It's the next judicial day. It's whichever of those two things comes sooner. So if you get one Monday evening, you have to get to the courthouse Tuesday and file for a petition for order of protection, get the temporary order of protection that next day where the emergency order expires. So 1 a.m. Monday, technically, okay, so that would be Monday at 5 p.m. is what it expires, but I don't know, time confuses me, and so I feel like if it confuses me, it might confuse someone else. Does that make sense? Does that answer that?
Yes.
Okay. Do we have any more?
I have a question. This is Tina with Alternatives to Violence. So they're unprotected technically until that temporary order gets signed once the emergency order expires, because it takes our courts, well, several days. Now they're saying it could take up to 10 days for them to get a temporary order.
Oh, that's really not right. Okay,
Yeah.
yes, they are. They are left unprotected in that time. Which area are you in?
We're in Raton.
Raton? Tina, at some point offline, can me and you chat about that issue?
Yeah, I'll probably have Janice join us.
Okay, and I can
Thank
have
you.
our Santa Fe office manager. I think that would be a really great conversation to have. And I will put my contact information in the chat. So Tina, if you would email me, we can talk about that issue offline.
Yeah, and then I'll clarify some stuff. Janice is going to sit in there with us so we can get that clarified. I might have It might be the temporary can come in within 3 days and then the others would be longer, but
Even
yeah,
3
we'll do it
days is a
offline.
long time. Yeah, but
Yeah,
no,
we'll do it
that is
offline.
accurate, that people are
Yes.
left unprotected if the court cannot issue and get you that temporary order of protection that next day when you file the petition. That does create a gap then.
Yeah.
So that is
All
that
right,
is
we'll
correct.
get on, we'll, that way we can get that figured out.
Okay,
Thank you.
absolutely. Terry, do we have any more questions?
Nope, that's all.
Okay, cool. All right, so moving on from the order to appear. So let's talk a little bit about temporary orders of protection. So the court is supposed to review the petition for order of protection and make that determination. They're supposed to make it the same day. Temporary orders of protection are supposed to have a hearing within 10 days. Some courts are really good about doing that. Some courts are really bad about doing that. It's not great when it doesn't happen quickly. But I also understand why it's not happening quickly. I will say in Albuquerque, I definitely see it sometimes last almost 30 days before they can get a hearing when things get crazy. I know in the heart of the pandemic, Sandoval County was having some issues and we were seeing long wait times with that. It's just the courts, you only want to push so much because you definitely want people to have quality hearings to make sure that survivors get enough time to say what they need to say. And so the capacity issue is always a challenging one to deal with. But under the statute, the hearings are supposed to happen within 10 days. Due to service issues, parties needing more time to prepare, all of these things, the court sometimes does reset these hearings. Really quick, and I'm not going to get in too much about the service issues on this one, but parties do, so the opposing party can file an order of protection against someone. The person it's filed against needs to be what's called personally served. That means physically hand one thing to the person. So police are supposed to go out and personally serve and physically hand the perpetrator this paperwork. Sometimes it can be a friend, a grandmother, a brother that also does this. If you don't know where the perpetrator is and he cannot be located, then under this, without that service, the court is not allowed to do anything. It's not because they don't believe the survivor. It's not because they don't think that the survivor has the need for protection. It is because they are prohibited from doing anything without that personal service. Stephanie, did you have a question?
Nope, accidentally hit it when I went to turn back on my camera.
Cool. All right. So with that, and that is a very, very frustrating thing. And I know that we work with people regularly, but just know that that personal service is vital for moving the case forward. But when the temporary order of protection is issued, it can do a lot. Like it has a lot of power in that temporary. It can tell them the perpetrator to have no contact with the survivor. It can evict the perpetrator from a shared residence, and it can do temporary legal and physical custody of kids. So temporary orders can do the custody. I don't think that emergency orders can, because it's just like a little check off thing. But like I said, I just can't visualize it entirely in my head right now. So I just note that a lot of people say I have an order of protection and then they move on after they file their petition. It's really important to make sure that people understand that that temporary order of protection is in fact temporary and you have to go to a hearing to have it extended. So we're not going to get too much into the hearings today, but I do want to make sure that you guys understand what the actual orders of protection can do. So there are two types of orders of protection. There's something called stipulated and there are contested. Stipulated is when both parties agree to the terms in the order of protection. So a lot of times when you get on the hearing, the judge or the hearing officer will ask the survivor, do you want this order of protection extended? And they say, yes, I want it extended for 5 years. And then the judge says to the opposing party saying, okay, Do you agree with that? And they say, yeah, no, that's fine. I don't want any contact for 5 years either. Say, okay. And then if there are children, they'll say, what kind of visitation do you want? The survivor will say, I want this and that. And if the other party agrees to it, the judge physically writes it all up, signs it, and it's in effect. It has the exact same effect as a contested order of protection. A violation has the same penalties associated with it. The only difference between a stipulated and a contested is the court does not listen to evidence, so they do not make a finding that the opposing party committed an act of domestic abuse. Now, sometimes those findings completely meaningless. Sometimes those findings are very important. So it really depends on the situation. Those findings can be used in future custody hearings. That's when it's important. So if they have kids, there's a little bit more of a question. But at the same time, the survivor, one, is getting what they're asking for, and two, is not forced to go through the additional trauma of testifying at a hearing. And those are significant benefits. And sometimes they outweigh the finding of domestic abuse, sometimes they don't. And that's something that, that's ultimately something that's up to the survivor. And I would always say, that telling them which to do constitutes legal advice. So I wouldn't recommend, honestly, throughout all of this, the important thing to remember is what is legal advice versus what is information. Because you guys can give all of this information, but saying your specific situation is domestic abuse because X, Y, and Z, that is going to be considered legal advice. So it's really, it's a hard line. But if you ever get in a point where you're like, this person needs legal advice and I can't give it to them, have them call that helpline. That's one of the things, like if you provide them all the information about this is what the statute says domestic abuse is, and they keep just saying, well, but what it is what I'm going through domestic abuse, that would be legal advice. And that's when you have them call the domestic violence helpline. Okay. And if you guys have questions about that, I am around for that. I understand you have a whole lot put on you with that. So please ask questions and you guys call me whenever and ask them. Okay. So back to this, contested order of protection, ultimately survivor testifies to what happened, opposing party tells their side of the story or doesn't, then the court makes a decision and says that there was an act of domestic violence that happened, they get a contested order of protection. So the way you get these is very different. The outcome is fairly the same depending on what it is. So the same things, the court has the ability to tell them that, let me back up and pick a sentence. Sorry, guys. The court has the ability to really make decisions about what the parties need. So that's the difference between these stipulated versus contested. I would say that there are times where I have clients who I really want them to have that finding, but that testifying is really scary. And so stipulated works out better. Or vice versa, where, honestly, the finding's not going to do much. They don't have children together, but they really want the opportunity to be heard. And so, it's very situation specific. So orders of protection have a lot of oomph behind them. And I recognize that we're almost to our question time, so I'm going to bump into it just a little bit, shockingly, because I talk too much. So ultimately, it's the stay away order. You can't talk to them, can't post about them on social media. They can grant sole possession of a home during the period of the order of protection. I just want to note they can't change who owns anything. The court is specifically prohibited. They can't say, oh, change title of the car or you now own the house. If they own the house together, the other person might still own the house, but they just can't go to it, or they violate an order of protection when facing misdemeanor. So they might still own it, but it just means they can't physically go there. Restitution, they can order the other party to pay for damages, medical bills, pay for that broken cell phone. They can't transfer, conceal, or destroy property. That is really a big deal. I would say the biggest time that's a the most important that that's a big deal is especially when the survivor is an immigrant and has either passports or birth certificates and stuff like that. It's a very common technique of abusers to destroy those kind of documents. And that's why one of the things I always do in safety planning is tell them to keep their documents somewhere that's easily retrievable if they have to leave quickly. But technically, if we find out that those documents are destroyed, that can be a violation of the order of protection. The court can make people attend counseling, domestic violence classes, parenting classes, alcohol, substance abuse. For the most part, they only do this if there are kids involved. They'll make them go to like domestic violence classes, but like the alcohol and substance abuse and stuff like that, the court's going to be much more likely to order something like that if there's also going to be custody issues down the road. And then there's the firearm, which is a newer law. I think it was passed in 2019, that if the court finds them to be a credible threat to the survivor, they can have to turn all of their firearms into local law enforcement. Or if they don't have firearms or say that they don't have firearms, they can still be prosecuted if they're found with firearms in their possession, both through the state and the feds. Custody attachments, temporary, physical, so who makes the decisions for the kids, and legal, who makes decisions for the kids, and physical, who physically has the kids. They can order temporary child support and temporary distribution of property. Okay, you go pick up the dresser, things like that. For these things, they only have 6 months. So they can issue an order of protection, so say no contact with the survivor for a very long amount of time. They can do it for a year, they can do it for 5 years, whatever the court decides. But when it comes to the kids and the money stuff, only 6 months. Otherwise, the survivor needs to file a divorce or custody case for longer term things. And we'll talk more about that divorce and custody case in our next part of the series. It cannot do permanent custody, cannot affect title, cannot do that. Some of your courts might read this, in my opinion, to the extreme and say that they can only issue an order of protection period for 6 months. I disagree with that, as well as many of the other jurisdictions disagree with that reading. If you're seeing that and you have cases that you want to talk about, talk to me about it, because a 6-month order of protection protecting the survivor directly, I mean, sometimes it's not worth it for what they have to go through. So if your jurisdictions are doing that, let me know and we can talk about it and we can see if we can think through some ideas. Just real quick, if you need to extend the order of protection, you should always go before the order of protection expires. Because if you go after it expires, you'll need the perpetrator to commit a new act of domestic abuse. But if you go before it expires, you can go and write out why you need the order of protection extended. You need to show the court good cause. So I would say, like, if the person is violating that order of protection, that's going to be good cause. And just real quick, civil restraining orders are a completely different process, and they do not require people to be household members. There's none of these type of requirements. However, you do have to pay a filing fee. Those are not free. Orders of protection and petitions for order of protection are free of charge for domestic violence survivors. So when people go to the courthouse, if they come out and they tell you they made me pay for it, that means the court is giving them a different type of restraining order, and it's a civil restraining order. Civil restraining orders are not arrestable. So if somebody violates a civil restraining order, the victim has to go back to the court, say, hey, judge, they're violating this, and then the judge has to do something. The police cannot come in and arrest someone for violation of a civil restraining order. They can arrest for a violation of an order of protection, which is the domestic violence ones we've been talking about. Those are the very, very main differences. So orders of protection are much more effective and much easier to enforce. So if somebody qualifies for a order of protection, 9 times out of 10, that is the way they should go. It's very rare that I would say someone should get a civil restraining order. And if people have questions about civil restraining orders, just let me know. I think we are pretty much out of time, but I will answer some questions and stuff like that. So does anyone have questions based on this?
Go ahead.
I'm just going to say you have a question in the chat. How about having the restrained party returning items such as bank cards?
So that is something that the judge can listen to either in a stipulation or a contested order of protection. Now I say can because the judges sometimes run out of time and just kind of say, oh, that's a case for, that's an issue for the divorce custody, or you can sue them in like small claims court. But my recommendation is always try to get things like that addressed. You can usually request what's called a civil standby to get police to go and pick up your items, but you should be able to get things picked up like that in the order of protection case itself, and the judge can absolutely order that to happen. It's just a matter of you have to have enough time for the judge to order it. Any other questions? I explained things perfectly. You guys, you actually understood me. Is that what I read this to me? All right. Well, so like I said, you guys are going to get the domestic violence helpline brochure. I also just want to take a quick second and let you know we have a VOCA project. We're going to be talking about that more in the 3rd section of our series, but we're going to send you a little bit of information about that, as well as this PowerPoint. If you have questions, my phone number's on there, my email is on there. Email me, let's talk about things. Each one of your areas has unique challenges, and sometimes I know about them, sometimes I don't. So if you're dealing with some stuff, like email me and let's talk about whether or not that's something the court's doing that's supported by the law or not supported by the law. Because if it's not supported by the law, there might be something we can do about it.
Thank you so much, Sarah, for being with us this morning. And the presentation was very informational. There's a lot of resource information there. As mentioned earlier, this session is recorded. And you will be getting the documents that Sarah mentioned, as well as her PowerPoint, so you all can look back at that. This will also be uploaded to our YouTube channel at NMCADB. You can all Google that or go to our new website where we do have the YouTube link there. And as mentioned, you will also get an email with all this information with your survey to attain your certificate for attending today. And this is the first session of a 3-part series. And so this will be the same link for the other sessions. And so no need to re-register. You will get the reminder from me as you did this morning and the day before, and probably an announcement on social media reminding you all for the 2nd and the 3rd session. And so we hope to see you all. And again, if you all have any questions, please reach out to Sarah or myself where I can forward them to Sarah, so you all get the resources or your questions answered. Maybe if you weren't comfortable asking them here during the session, but if you would like to send an email, please do so. Other than that, thank you all for being here with us today for your first session. And let us know if there's anything that you all have questions on and would like also future trainings on. Thank you so much, Sarah, again for being here, and I look forward to seeing you next month and for session number 2.
Thank you guys so much.
All right, everybody, have a good day.